Thank you. Professor, are you a member of the Delaware Bar?
Senator, I am a member of the Virginia and Maryland bars as a longtime public servant here in this area.
Have you ever practiced law in Delaware?
Senator, I am admitted to the Third Circuit. I've practiced law, as I mentioned, as a public servant, mostly here in government.
Have you ever practiced law in Delaware?
Senator, I have not. I've practiced law in this area.
Have you made any argument in the federal or state courts of Delaware?
Senator, again, as a public servant.
You can treat these as yes and no questions, please, Professor. Have you ever filed a brief in a Delaware court?
Senator, I filed a brief in the Third Circuit. As your questions point out, as the president's nominee to the Third Circuit, I've been nominated to a seat that by custom now is within Delaware, and would look forward, if this body were to confirm me, in joining the legal community specifically in Delaware. I would plan to have chambers in Wilmington, but right now my practice has been as an academic and here in Washington, D.C. as a public servant.
So your record of scholarship and public commentary, advocacy, is quite lengthy, but I'm concerned that your actual practice is quite short. How many depositions have you taken or defended?
So, Senator, as principally an appellate lawyer and
I think the answer is none. How many motions in limine have you argued?
Senator, my practice has been mostly at the appellate level. So I've filed dozens of appellate briefs. I have not argued motions in limine. I did argue to verdict, however, as the record shows, a district court case defending the Title IX for the Department of Education, and so have argued in both district and appellate courts on behalf of the federal government.
My point is simply that the Third Circuit's docket is substantially made up of criminal cases, bankruptcy cases, patent cases, very little in terms of constitutional administrative law, which is your specialty. And you've been nominated to essentially rule on appeals from the district courts, in particular the district courts of Delaware, and this long, long tradition of states getting to choose a member of their bench and their bar to go to a circuit is so that the values and the tradition, the legal concerns of that state are most respected. Let me move to your substantive work, because my core concern is that our framers drafted a constitution in order to constrain powers, the separation of powers, which you've taught. They put Congress as the Article I branch, not the president, because they were principally concerned about constraining an overreaching executive. In a brief that you filed challenging President Biden's effort to cancel student debt, you wrote, "The power of the purse is one of Congress's most potent checks on the executive branch." I asked you yesterday if you'd ever advised the White House on impoundment issues, whether President Trump could refuse to spend money Congress has appropriated, and you said that you had. Did you advise the White House President Trump can refuse to spend money legally appropriated by this body?
So Senator, I appreciate your question reference to Article I and appropriation. I know we talked about that a bit yesterday, and also, having clerked for Judge Kavanaugh, he, as a former executive branch lawyer, also pointed out the president's role in having to sign off or veto legislation. The particular question you talked about, I believe, I recall in our discussion that I had mentioned that I had not been working on that issue recently, that I was asked a discrete question actually prior to the start of the administration on the constitutional question that are related to that topic. But beyond that, really sitting here today as a judicial nominee with some of these issues playing out in the courts as we speak, I cannot further comment on the question.
You publicly stated in March of this year that the Supreme Court's 90-year-old Humphrey's executor case was wrongly decided. Do you stand by that statement?
So, Senator, as an academic, and I've taught in other forums, I strongly stand by my past work. Sitting here as a judicial nominee, what I also mentioned yesterday a number of times was my commitment as a lower court judge to a fully and completely applying Supreme Court precedent, and also the case that you mentioned, Humphrey's executor, in the Supreme Court's own writings that has referred to it in the past decade, 10 or 15 years, as a narrow exception to the broader principle that the president, vested with the executive power, needs to supervise the executive branch, and I would apply all those principles fully.
You were just in an exchange with Senator Lee where you talked about the importance of hewing towards the text. I think the Federal Trade Commission Act of 1914 could not have been clearer. In fact, the Humphrey's executor decision was a unanimous decision by the Supreme Court, and it has been respected not as a narrow exception, but as, frankly, the foundation of the boundary between the president and dozens of critical regulatory agencies. It prevents a president from whimsically removing based on partisan, political, or policy differences, something FDR was trying to do to a member of the FTC. Yesterday, the D.C. Circuit reaffirmed the holding of Humphrey's executor. Why should we have confidence that we can count on you to uphold this 90-year precedent that just months ago you have argued was wrongly decided? Will you recuse yourself from cases applying that precedent, given your advocacy for its reversal?
So, Senator, if I were to have the honor of this body to confirm me, I would follow all statutory recusal requirements, and I understand one of those requirements to be to recuse from particular matters on which I would have worked, and also cases where I might have a financial interest at stake, and of course I would fully comply with all statutory recusal requirements.
Last question. Do you think Congress can constitutionally restrict the removal of any official in the executive branch on any basis, whether it's for inefficiency or neglect of duty or malfeasance? Because as is currently being hotly contested, there are critical boundaries between Article I and Article II powers, and you have been a relentless activist on behalf of expanding the scope of executive power. Is there any way Congress can restrict the removal of any executive branch official?
Senator, as you point out with it being contested, the contours of the constitutional power of Congress to constrain the president's supervisory power or to fashion characteristics on the contours of the institution of offices is currently being contested in courts, and so I'm not going to be able to speak to the absolute merits on that question. We did discuss Congress's role in fashioning and creating offices. We discussed the president's power to supervise the executive branch, and as I mentioned, if I were to have the honor to be confirmed, I would fully and faithfully apply the text and structure of the Constitution and decisions by the Supreme Court, of which I would be fully bound. Thank you.
Ms. Mascott, you come from a great family. You've been a fierce, determined, and capable professor. I appreciate our conversation yesterday and your answers to my questions today. Thank you.
Senator.
Senator